in our Constituent Assembly. This 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much. I would now like to invite our esteemed guest speaker, Professor Dr. Jasmeet Gulati ma'am, to kindly proceed with the webinar and illuminate upon the topic, Honoring our Constitution, Embracing Global Commitments. Ma'am, we welcome you.
Thank you, Glory. A very good afternoon to Dr. Shweta Vigneta, who is the Director, FIMT School of Law, to the faculty of FIMT School of Law, students, ladies and gentlemen. Thank you for having invited me for this very special occasion. And as we celebrate the 75th anniversary of the adoption of the Constitution of India, this Constitution Day, it is my honor and privilege to speak today to mark this special occasion. India has come a very long way since 1949, when the members of Constituent Assembly finally gave us the Constitution. There have been 106 amendments to the Constitution of India since then, which is a reflection of the dynamism of Constitution to be able to adapt to changing national and international obligations. India has now procured a seemingly good position at the international level. There are many countries in Asia, Africa, Europe, and the Americas looking up to India for support and cooperation. These countries have great hopes from the partnership with India. India has always kept a peaceful stance vis-a-vis other states, including in the present situation, the present conflicts in which India has not allied with anyone. India is under an obligation not only under various international treaties and conventions, but also under its own constitution to promote international peace and security. And in the same stride, I'm happy to speak on India's constitutional commitments to international obligations and how India has respected its international obligations by implementing various provisions of international conventions, not only through passing of law by the legislature, but also by an active role that judiciary has played. International law, as is reflected through treaties, international customs, and general principles of law, respects sovereign equality of states. There is no sovereign political authority above the states in the international legal system, as we all understand. Rules of international law, they are created by common consent of states. The international obligations arise out of the customary international law as well as international conventions that are ratified by the respective states. The treaties are binding based on the principle of pacta sunt servanda, which means that states are bound to fulfill in good faith the obligations assumed by them under treaties. There is no provision under rules of international law which makes it obligatory for states to make laws under their municipal system for implementing treaties. For example, if any country, including India, signs a treaty, so we are under no obligation that we have to also pass a legislation in our country. One of the most significant institutions to administer international law, as we all understand, is the United Nations Organization. The Charter of United Nations is based on the true legality of international law. One of the main purposes of the United Nations is to maintain international peace and security and to develop friendly relations among nations. India, being the founding member of the United Nations, strongly supports the purposes and principles of the United Nations and has endeavored to promote international peace and security also under the provisions of Constitution. Article 51 of the Constitution provides that The state shall endeavor to promote international peace and security, to maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealings of organized peoples with one another, and encourage settlement of international disputes by way of arbitration. India has made significant contribution in promoting the purposes of United Nations through its constitutional provisions and the role that judiciary has played, which we usually often call it as judicial activism. The Constitution provides that India shall endeavor to promote international peace and also foster respect for international law. This provision was adopted in the Constitution upon the realization that there could be no peace or progress within the country if there was war in which the country is involved. So it embodies the objective of India in the international sphere as a member of international community and international civilized order. I must mention here that this provision forms part of the directive principles of state policy. The directive principles as enshrined in in part 4 of the Constitution are fundamental in the governance of the country, but they are not enforceable by any court. These are the guiding principles for the legislature while framing laws. Although this form part of the directive principles, but it cannot be overlooked that the state is duty bound to apply these principles in making laws. In the landmark judgment of Supreme Court in the case of Kesavananda Bharati, as we all know, most of the outstanding judgments, the nature and object of directive principle is also stated, and I quote from this judgment. The directive principles of state policy set forth the humanitarian socialist precepts that were the aims of the Indian social revolution. It's a comprehensive judgment which includes so many other aspects of Constitution. Whenever action is taken by the state in consonance with the provisions of the directive principles, the same is considered to be a reasonable action. The courts are bound to evolve, affirm, and adopt principles of interpretation that will further the goals that are set out in our directive principles. In MRF Limited versus Inspector Kerala government, it was observed by the Apex Court that the directive principles are not enforceable, but are fundamental in the governance of the country and have to be applied by the state in making the laws. Therefore, the legislature, while framing laws, must ensure that the laws are in consonance with the directive principles. Hence, the rules of international law must be respected by the legislature by framing the laws. Directive principles are also binding on the courts in the matter of interpretation, that is, interpreting the Constitution to realize the goals to realize the goals that are mentioned also under the directive principles, because it is through legislation they are realizing the goals of the directive principles, and also the role that judiciary is playing. India, as part of its constitutional commitment, constantly endeavors to give effect to treaties and international customs by enacting various legislations, which they are obliged to do so also under Article 253 of the Constitution. Well, Article 253 provides that the Parliament has the power to make law for the whole or any part of the country for implementing any treaty, agreement, or convention with any other country or countries, or any decision made at the international conference, association, or other body. The Constitution itself clarifies that for implementing any treaty obligations, a law has to be passed by the legislature, and this is in conformity with the object declared by Article 51C. Now, in India, the provisions of treaty, once signed, they do not automatically form part of the law of the land. The doctrine of monoism as prevailing in European countries is not applied in India, but it is the doctrine of dualism which is applied in India. A treaty entered by India cannot become a law of the land, and it cannot be implemented unless Parliament passes a law. The obligations arising under the agreement or treaties are not by their own force binding on Indian nationals. The power to legislate in respect of treaties, as we all know, lies with Parliament and also provided under the constitutional provision, Article 253. The state practices pertaining to incorporation of international law into municipal law are best explained by two schools of thought, as I just mentioned, which is one is monoist and the second is dualist. So monist theory was propounded in the 18th century and was put forward by two German scholars, Mosier and Martens. And it was further developed by Calson, an Austrian jurist. This approach does not distinguish international law from national law of the states, and accordingly, rules of international law do not need to be transformed into national or municipal law through any further national legislation, and therefore the rules of international law can be applied as such by municipal courts. The moment the state signs any treaty, it is automatically, it becomes law of the land. You don't need any internal legislation, internal law to be passed by the by the legislature or the parliament. So the rules of international, including those in the treaty, automatically become effective and incorporated in the municipal law as soon as the state ratifies a treaty. So this is a monist theory, which we, as in India, we do not follow. And in a monoist state, the court can declare any national rule of law invalid if it contradicts with the international rule of law. And thus, it establishes superiority of international law even within the municipal spheres. Those who are following monoist school of thought or monist school, they give preference to international law as opposed to national law. So the Netherlands and Germany, they are the best examples of states having monoist approach. So most of the European countries, they are doing that, including, in fact, the Western side, that is the Americas. So many states expressly accept international law as part of their domestic law, while others, they do not accept so. So where international law becomes incorporated in a state's domestic law without the need for specific legislation, those parts of it are also known as self-executing. And some states provide in their constitution that certain provisions of international law shall be self-executing. For example, the Constitution of US. It provides that international treaties are part of the law of the land. Other countries, they have gone even further by not only making international law self-executing, but assigning to it a rank in the domestic hierarchy superior to all prior and subsequent legislation. So even prior legislations or subsequent legislations, they would be under the treaty provisions that have been ratified by this state. And examples of this are France and Germany. So there are other states that do not accept any international law as self-executing, for example, United Kingdom. And these states are dualist states, also includes India. Now, according to dualist theory, international law and municipal law, they are two distinct, separate, and self-contained legal systems. And so international law would not as such form part of the national law of the state. In such a state, legislature must pass law to give effect to the treaty, since ratification of a treaty by the concerned state does not result in automatic incorporation of that treaty in the domestic legal system. This view was propounded by German scholar Triple in 1899 and was further developed by the Italian jurist Enzilotti. This theory represents that international law has different character from that of national law. Now, according to dualist school of thought, the municipal courts shall apply municipal law in case of a conflict between international law and municipal law. So therefore, municipal law has primacy over international law, according to this school of thought. And in Britain, international law becomes part of the law of land only when it is accepted in Act of Parliament and through any legislation, their internal legislation. A treaty has no effect in municipal law until an Act of Parliament is passed to give effect to that treaty. So international law does not determine which point of view is to be preferred. It is left to the discretion of the state to decide according to their legal traditions or national structure. Now, India more closely follows the dualist pattern, which is also evident from the provisions of the Constitution. In case of State of West Bengal versus Kesoram Industries Limited and others, a 5-judge constitutional bench of Supreme Court observed, and I quote, "It is true that the doctrine of monoism as prevailing in the European countries does not prevail in India. The doctrine of dualism is applicable. But where the municipal law does not limit the extent of the statute, even if India is not signatory to the relevant international treaty or covenant, the Supreme Court in a large number of cases interpreted the statutes keeping in view the same," unquote. So hence, this means that even if India has not ratified or signed any treaty, but if it does not conflict with the internal law, Supreme Court has also interpreted to give effect to that kind of a treaty. The courts in India have played an important role in overcoming the challenges in implementing the provisions of treaty to protect the rights of its citizens. Courts in certain cases have refused to implement treaty provisions in municipal courts without any legislation to that effect. But at the same time, it has upheld the provisions of human rights treaties and given effect to those provisions where there is no contradictory municipal law. And judiciary has played an important role over the years in realizing certain provisions of international conventions and protecting the rights of its citizens by basing its decision on international legal principles. So in Xavier versus Canara Bank Limited, the issue that came up before the Kerala High Court was whether the provisions of international treaties to which India is a party become part of corpus juris of India. More specifically, the question pertained to whether Article 11 of the International Covenant on Civil and Political Rights, which provides that no one shall be imprisoned on the ground of inability to fulfill its contractual obligations, has become part of municipal law of the country and conferring right to remedial action at the instance of any aggrieved person. So the court held that the remedy for breaches of international law in general is not found in the law courts of the state, that is India. Because international law per se does not, it has not the force or authority of civil law. So if the courts have to apply, they can't apply a treaty and decide a case. They will have to look into any municipal legislation. So it is further observed in this particular case that although the UDHR sets a common standard of achievement for all peoples and all nations, but individual citizens cannot complain about their breach in municipal courts, even the country concerning has adopted a covenant and even if they have ratified the protocol. The court also stated that the basic human rights enshrined in the international covenants may at best inform judicial institutions and they can inspire legislative action within the member states. But apart from this deep reverence, remedial action at the instance of an aggrieved person is not within the purview of the judicial authority. Another case of Jolly Verghese versus Bank of Cochin, the Supreme Court also dealt with the matter concerning effect of international law and its enforceability at the instance of individuals within the state, that is India. So the Apex Court observed that the positive commitment of the state parties ignites legislative action at home. So if you have signed, ratified a treaty, all you can do is you can come back and you can enact a law to that effect. But it does not automatically make the covenant an enforceable part of law in India. Also in Magna Bhai Ishwar Bhai Patel versus Union of India, the Constitutional Bench of Supreme Court held that the effect of Article 253 is that if a treaty, agreement, or convention with a foreign state deals with a subject which is within the competence of state legislature, the parliament alone has the power to make laws to implement the treaty or that agreement or convention or any decision made at the international conference. Further, also in the year 2005, the Apex Court in the case of State of West Bengal versus Kesoram Industries Limited held that a treaty entered into by India cannot become law of the land. It cannot be implemented unless Parliament passes the law as mentioned also under Article 253. So these observations of Supreme Court and the cases that I've just mentioned, they only reflect the dualist school of thought according to which a treaty becomes a law of the land only after its transformation into the law by the legislative process. Now, the common law countries which are following dualist pattern requires the act of parliament to transform treaty into the national legislation. But at the same time, the common law countries maintain that the rules of international customary law, and I'm not talking about treaties law, I'm talking about the international customary law, they are part of municipal law if they are not inconsistent with the municipal law. Now, the Apex Court in India has also followed this rule. Specifically, if I'm citing this case, that is People's Union for Civil Liberties versus Union of India. The Supreme Court regulated telephone tapping, which is permitted under Section 5, Clause 2 of the Telegraph Act. The court took into consideration the right to privacy implicit in Article 21 of the Constitution, but also it recognized the Article 12 of the UDHR and Article 17 of the ICCPR. It further held that rules of customary international law, which are not contrary to the municipal law, shall be deemed to be incorporated in the domestic law. We've seen a shift in the approach of Supreme Court, as in earlier cases, the Honorable Court held that a treaty entered by India cannot become law of the land. But in the later cases, for example, as I just mentioned, People's Union for Civil Liberties, the court observed that rules of customary international shall be deemed to form part of municipal law, provided it is not in contradiction to the enacted law. Hence, though the court cannot directly make the law, which is the functions of the legislature, it may apply Article 51, where there is no contrary authority binding on the court. The positive approach of the Supreme Court towards acceptability of the principles of international law is further heightened in the case of Vellore Citizens Welfare Forum versus Union of India and others. Now, the Honorable Court upheld the validity of principles of sustainable development in this case, sustainable development, polluter pays principle, and also the precautionary principle. It held that once these principles are accepted as part of customary international law, there would be no difficulty in accepting them as part of the domestic law. So it is almost accepted proposition of law that the rules of customary international law, which are not contrary to the municipal law, shall be deemed to have been incorporated in the domestic law and shall be followed by the courts of law. Then another case of Gramophone Company of India Limited versus B.B. Pandey. The Supreme Court observed that the Committee of Nations requires that the rules of international law may be accommodated in the municipal law even without express legislative sanctions, provided they do not run in conflict with the Acts of Parliament. The Supreme Court has played a very important role in implementing treaty obligations in the case of Vishakha and others, as we all understand, the most important, the landmark judgment, wherein the apex court, by promulgating the guidelines on women's sexual harassment, has held that in the absence of domestic law occupying the field, to formulate effective measures to check the evil of sexual harassment of working women at all workplaces, the contents of international conventions and norms are significant for the purpose of interpretation of the guarantee of gender equality, right to work with dignity in Article 14, 15, 19, 21 of the Constitution, and the safeguards against sexual harassment which are implicit therein. Now, any international convention which is not inconsistent with the fundamental rights and in harmony with its spirit must be read into these provisions to enlarge the meaning and content thereof. And that is primarily to promote the object of the constitutional guarantee. The court further observed that it is now an accepted rule of judicial construction that regard must be had to the international conventions and norms for construing domestic law where there is inconsistency between them and there is a void in a domestic law. So whenever there will be a void in domestic law, they can always apply the rules of international law, reflecting treaties or reflecting customary international law. The court referred to its own decisions in case of Neelabati Behera versus State of Orissa and others. The court in this case observed that there is no reason why these international conventions and norms cannot be used for construing the fundamental rights expressly guaranteed in the Constitution of India. Also in Geeta Hariharan versus Reserve Bank of India, while interpreting the right of guardianship of mother when the father was alive under Hindu Minority and Guardianship Act of 1956, the Convention on the Elimination of All Forms of Discrimination against Women was again relied on. So also denying maternity benefit to some of the women employees of Municipal Corporation of Delhi was held invalid, relying on Maternity Benefit Act 951, which was read along with Article 11 of this CEDAW Convention. Then in 2014 judgment also in case of NALSA, National Legal Services Authority versus Union of India and others, on recognizing transgender as third gender and enforcing their rights guaranteed in the Constitution as citizens of this country, the Supreme Court again referred to the provisions of international conventions. The Honorable Court observed that generally a legislation is required for implementing the international covenants, unlike the position in the US, as we just mentioned, where the rules of international law are applied by the municipal courts based on the theory of their implied adoption by the state, which is as a part of its own municipal law. In the US, till the act of Congress is passed, the courts, they are bound by law of nations. So if there is an act of Congress passed, then only they will apply that law. Until then, it is the law of nations, which is part of the law of land. The apex court in India, while referring to the Indian position with respect to the implementation of international treaty obligations into municipal legal system, observed that such a supremacy clause as is adopted by the US is absent in our constitution. Courts in India would apply the rules of international law according to the principles of Committee of Nations unless they are overridden by clear rules of domestic law. The court held that the covenants which India has ratified can be used by the municipal courts as an aid to the interpretation of statutes by applying the doctrine of harmonization. And therefore, if the Indian law is not in conflict with the international covenants, particularly relating to human rights, to which India is a party, the domestic court can apply these principles in Indian conditions. In that case, the rights of transgender and their protection against discrimination were brought to surface, and the Supreme Court gave due regard to international conventions and norms for the protection of rights of transgender community. The court highlighted the significance of international conventions and the rights covered under these conventions for the third generation, for the third gender. The court also referred to United Nations Convention Against Torture and other cruel, inhumane, and degrading treatment or punishment that deals with protection of individuals and groups made vulnerable by discrimination or marginalization. The court, while interpreting Article 51, read along with Article 253 of the Constitution, held that if Parliament has made any legislation which is in conflict with international law, then Indian courts are bound to give effect to the Indian law. However, in the absence of contrary legislation, municipal courts in India would respect the rules of international law. So therefore, the Indian commitment to international treaty obligations under Constitution of India is defined under Article 51C, which, although is a directive principle, yet the power of Parliament under Article 253 to enact laws for implementing the treaty obligations is an important provision in this direction. The Honorable Supreme Court has given effect to treaty obligations, especially in case of Vishakha and others versus State of Rajasthan and others, and in the later case of Nalsa versus Union of India, which was regarding the third gender. The Supreme Court has given importance to the rules of international law and treaty obligations in the national courts. It can be inferred from all of these that it is the dualist approach that India is following. But now looking at these later cases, for example, the Vishakha case or the Nalsa case, we see that India is now moving towards monoist approach. The courts in India may enforce international treaties and conventions which are not inconsistent with the Indian laws. Also in Vellore Citizen Forum case, it was held that the rules of customary international law, which are not contrary to municipal laws, are deemed to have been incorporated in the domestic law. And they did mention the principle of sustainable development as a balancing concept between ecology and development, which is part of customary international law. And also they referred to precautionary principle and the polluter pays principle, which are the essential features used for construing the functions of the authority under Section 3, Clause 3 of the Environment Protection Act. So we have seen that how India is now giving effect to these international treaties, international conventions, and we see the approach of Indian courts to move towards more of a monoist school of thought. So this only reflects how rules of international law under various conventions, customs are being applied by municipal courts in India without waiting for the legislature to frame laws to meet the ends of justice. The Supreme Court can mold and lay down the law formulating principles and guidelines as to adopt and adjust to the changing condition of society, and ultimate objective being to dispense justice. The recent decisions of the Supreme Court reflect the trend towards this approach, whereby the provisions of international treaties have been enforced in the court of law, This bent towards the monist approach is also in line with the current approach of the Indian state as leading voice in the global south. This also brings out the dynamism of our constitution, which is a forward-looking document. And on this day, I congratulate one and all, and let's celebrate this 75th anniversary of the adoption of our Indian Constitution. Thank you very much.
Thank you so much, ma'am. I extend my heartfelt gratitude to our esteemed guest speaker for sharing her expertise with us. The webinar is now open for the questions. Participants are requested to ask questions by raising their hands. I repeat, in case of any question, participants are requested to raise their hand. We'll unmute.
Ma'am, I had one question.
Yes, please go ahead.
Good afternoon, ma'am. Ayush Avasti this side. Ma'am, so ma'am, as you mentioned the landmark judgment of NALSA versus so ma'am, I wanted to know more about it and how it is related to more of a constitution thing.
Specifically, this NALSA judgment I mentioned with regard to how we have applied the international treaty, since we did not, although in our constitution, we do have right to equality, but the third gender they were not accepted as a separate citizen. So even the constitution, and if we look at other laws, they mention man and women. So the third gender as a citizen was not accepted as such. They did not get those rights, wherein in this particular judgment, they had applied also the International Covenant on ICCPR, and they also applied the UDHR provisions of UDHR to bring in that kind of equality and give them that identity.
Okay, ma'am. Thank you so much.
Anyone else who wants to ask a question?
Okay, I assume everyone is done with the question and there are no further questions. Okay, so now I invite Dr. Shivani Singh ma'am to present the vote of thanks.
Good afternoon, everyone. Am I audible, Kirti? Am I audible?
Yes, ma'am, you're audible, ma'am.
Oh. Good afternoon, everyone. It is an honor to extend a vote of thanks on behalf of FIMT Pro Bono Club for this enriching webinar. First and foremost, I would like to express my deepest gratitude to our resource person, Professor Dr. Jasmeet Gulati, madam, for sparing your valuable time and sharing your expertise with us, madam. It was a meaningful lecture that will resonate with us for a long time. I would also like to thank our respected director, Professor Dr. Shweta Gagneja, ma'am, for her leadership and guidance in organizing this event. My heartfelt thanks to the management of FIMT, whose continued encouragement and backing has made this webinar possible, to all the students and faculty participants for the active participation, And I extend my gratitude to the Pro Bono associates, the students who work behind the scenes and ensure the smooth functioning and execution of the webinar. And let us continue to collaborate, learn, and grow together. Thank you.
I also want to extend my heartfelt gratitude to Madam Jasmeet Gulati for sharing your insight and integrating beautifully the provisions of the Constitution and the international law. Thank you once again, ma'am. And thank you so much for joining and sharing your words of wisdom with our students. Thank you so much.
Thank you so much. And I hope you all had a meaningful and enriching experience. Thank you and Jai Hind.